Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up.
Hearing's all present, counter for Your Honor.
Thank you. Please be seated. All right, we're back on the record on case CR 22211623, State of Idaho versus Chad Guy Daybell. We just concluded the lunch recess. At this time, the state completed its closing argument. It's now time for the defense to make its closing argument. Mr. Pryor, is the defense ready? Yes, you may. Okay, we'll enact that, and you can use the wireless microphone as well.
Folks hear me? Okay, thank you. I promise you, got about 15 slides. Not going to be long. I want to touch on a few points, and then I want to spend a little bit of time talking to you folks a little bit about the case, okay? I promise you this isn't going to take 2 hours. It'll be briefer, but there are some points that I need to touch on, and then I would respectfully ask for your attention in regards to that. I want to start out with the first slide, and the reason I did this is because in order for there to be a conviction, there's a chain of links that the prosecutor attorney has to go through. Chad Daybell, the first link is that he's presumed innocent. He's presumed innocent now. He was presumed innocent during the trial. He's presumed innocent throughout the trial. When it goes back to the jury and you consider the evidence, that's when you make the decision. And that's how that works. Throughout the trial, from the very beginning to the middle to the end to today, the entire burden has been on the state, okay? And the definition of what has to be proven by the state is beyond a reasonable doubt. State must prove every element beyond a reasonable doubt. Now, you've heard some information previously from the other attorney about what the state has to prove. One of the things the state has to prove in regards to the conspiracy charges is that there was an agreement, okay? And if you recall, when we were going through the voir dire process, that fancy French word that talks about when we were trying to select the jury, I talked to you and asked a number of you what an agreement is. What do you believe an agreement is? Okay? But the state has to prove that Chad Daybell with Lori Vallow or with Alex Cox or with other co-conspirators that they haven't named, with one of them entered into some sort of an agreement to kill the children and to kill Tammy Daybell. And then you have to show that Chad's involvement in that. That's the next thing the state has to show. Then they have to show that there was evidence of the murder. Jury instruction number 3 talks about, again, what I just talked about. The defendant, Chad Guy Daybell, has been charged in the amended indictment with certain counts of conspiracy with Lori Vallow and or Alex Cox, who's deceased, and or other conspirators, both known and unknown. And then it goes on, and I'll talk this a little bit up. The crime of conspiracy involves an agreement by 2 or more persons to commit a crime. Okay, it can't be an agreement that we have consistent religious beliefs. It can't be an agreement that we talk about religion unless there's an extra step. And that extra step has to be, we are going to kill these children. We are going to agree to kill Tammy Daybell. You can hear all the testimony in the world about dark spirits. You can hear all the testimony in the world about light and dark. You can hear all the testimony in the world about death percentages. And if you remember when we talked about death percentages with Officer K, who I think is here today, one of the text messages or the messages that he put up that he pulled off when he did his Google search is about Tammy and Chad talking about death percentages, talking about light and dark. You heard from Emma Murray how Emma Murray talks to her father. Now, they used a different term, but in Chad's traditional religion, his traditional LDS faith, it was not uncommon to talk about light and dark. It was not uncommon because we showed you the message between Tammy and Mark and Chad where they talked about death percentages. Okay? Now, the state brings up, yes, oh, Chad put a death percentage on Tylee and JJ and Tammy, and they're all dead. But you also heard testimony from one of the state's experts that said, we don't know if it was a high number or a low number, and there's confusion as to what that means. And I'd like to go back to the discussion that we had with one of the FBI agents who mentioned that there were thousands and thousands of messages, an enormous amount of evidence here. You heard from my expert, Patrick Eller. He talked about, I think the Library of Congress holds 1 terabyte of evidence if we went paper to paper through the whole building. And we had 6 terabytes, 6 bounds of paper that would fit in 6 libraries of Congress. And what has happened is you've been shown a handful of text messages that talk about a plan, that talk about death percentages, that talk about light and dark, talk about a variety of subjects. But what you didn't hear is you didn't hear about the thousands and thousands of messages that talked about religious beliefs, talked about a variety of other topics. And if we look at each and every one of ours position, you can always find a text message or a message of some kind that may be slanted or turned in a way to benefit one position or another. And that's not particularly uncommon. How often is it you send out a text message to somebody and it's misconstrued? How often is it that you send an electronic message to somebody through an email and it's misunderstood? Or maybe it's looked at in a different way. You know, as a society, we've lost our ability to communicate. Doing what I'm doing today is a lost art. Lawyers have to do this, especially in our position. But many of people who are in jobs, what it's done is send me a quick email, send me a text message, tell me what you feel. And sometimes those messages can be construed. The prosecuting attorney talked about, oh, there was a plan, and insinuating to you, suggesting to you that this plan was to kill the children. And at no time did the prosecuting attorney show you a text message that said, let's kill the kids, let's kill Tammy, okay? Instead, they talked about a plan. This is what we're looking to do in the future, okay? That's what they said to you, and they're trying to insinuate or suggest to you that in some way that means, well, that means that we're gonna kill the kids. No, the plan was, and whether you believe with Chad's religious beliefs or not, whether you accept his religious beliefs, the 144,000, that's his beliefs. He was a gatherer. He was a gatherer of the 144,000, and he said, I want to gather people, the sick, the elderly, the children, the impoverished, those that can't handle for themselves, and those that may be able to go on and become a part and parcel as this gatherer that he suggests would put together the 144,000 in Rexburg. Now, whether you think that's crazy or not, it doesn't matter. Whether you agree with light and dark, it doesn't matter. Whether you agree with death percentages, it doesn't matter. He's entitled to his beliefs. Every one of us has beliefs. Every one of us believes, has a certain core set of beliefs that we believe in. And think about, are they all rational? Maybe not. Maybe not. Everybody has pursuits that they want to pursue and things they want to do in their future. You know, I wanted to be a professional fisherman. Not really good at fishing. Wasn't going to work out. Wasn't going to make a lot of money, but it can still be a dream. I always wanted a 30-inch waist. That's not happening, folks. It's just not going to happen. I'm too old and maybe not as motivated as I should be. But we all have dreams. Now, how do we know these are dreams that Chad talks about? Because for 15 years, he was writing books. He was writing books about things that he was passionate about. And if you know anything about authors, when they're passionate about something, anybody comes up to them and brings up a subject and says, let's talk about religion. You've opened the floodgates. And it's very easy for you to go out there and say, I want to talk about my religion. I want to tell you all about all of these things. And at some point, when you start writing books and you go to these preparing the people conferences, and you meet all of these people, and you feel like, well, maybe I've become a little bit of a celebrity. Okay? In this case, I don't want to become a celebrity. I've had enough now at this point. But you know, Chad writes books. And he goes to these conferences and he talks about all of these religious beliefs. He talks about his premonitions. He talks about things that he thinks he can predict. Do you believe him? You don't have to. You don't have to believe anything he stands for. Nobody does. But he has a right to talk about it. And he has a right to say what he wants to say. And that's one of the distinctions, folks. Involves an agreement. It requires an agreement. You don't get to the overt acts. You don't get to all of the things the prosecutor has said about all of the things these people have done until you establish that Chad Daybell, by
Woohoo,
evidence
Betsy,
and
29
testimony
months. Thank you so much.
in the last 2 months,
Welcome in, everyone. We got
has
about
shown
15 minutes till
that
doomsday
there's been an agreement
time.
between him and Lori, him and Alex, or anyone else. There's no agreement. Show me the text message that says there's an agreement. Show me the text message that says this is what we're going to do. You were shown some things that talk about plans. Yeah, the plans of the 144,000. The plans of putting together this village of people to help all of these people out and do all of this. Traditional Mormon faith beliefs. Traditional Mormon faith beliefs. Those traditional Mormon faith beliefs that also included things like celestial marriages, being able to marry someone in the celestial realm and do that, going to a temple and saying, up there, I'm allowed to get married in the celestial because that's what we were taught. That's traditional. I'm allowed to do all of these things. Now, whether you agree with that or not, it doesn't matter. But if you have a core set of beliefs, and those are things you believe in, that's not a crime. The crime only comes into play. The crime of conspiracy involves an agreement to commit a crime. You should only consider the evidence against the defendant Chad Guy Daybell in this case and should not speculate as to any other case or legal proceedings involving alleged co-conspirators. When I first started with you folks with the voir dire process, again, that fancy French word that I always mispronounce, I talked to you a little bit about speculation. I talked to you about hunch. I talked to you about conjecture. I talked to you about guess. They all mean the same thing. The judge's instruction and what this judge has told us we have to do, and I put it up there for a reason. You must only consider the evidence against the defendant Chad Daybell in this case. It says it in the third instruction that you're going to read. Only in this case. The evidence that you have heard, they have not established an agreement. They have not given you any proof that there's any kind of an agreement. Read the overt acts. They espoused religious beliefs. That's what it says in the conspiracy charges. We espoused religious beliefs. Chad espoused his religious beliefs. Unless there's agreement, it doesn't matter whether he espoused his religious beliefs or not, because everybody's allowed to espouse their religious beliefs. I can tell you all about my religious beliefs. I can tell anybody, you could all talk all day long about our religious beliefs. But unless there's an agreement to commit a crime, you can talk all day long about your religious beliefs. You could say anything you want. I can say there's a little green man in my backyard, and I get to dance around with him and talk about religion all day long. And whether you believe it or not, it doesn't matter, but I'm entitled to my opinion to say that. And unless I can get into an agreement to commit a conspiracy, all the overt acts in the world don't matter. So there are two overt acts in the conspiracy that they talked about with JJ and Tylee. They killed these kids because of Chad's religious beliefs. That's what they're saying. His religious beliefs and all of this talk about dark and light was the reason Chad, Lori, and Alex killed these kids. Okay. And then, oh, by the way, the other overt act. Chad Googled south-southwest wind. And yet we heard from Emma Murray. She said, I Googled south-southwest wind. I had an event like Joe Murray's 5K race to see what the weather was going to be like, or another event that Joe was involved in. And she Googled it a short time before that event. You have to have an agreement. Again, do not speculate as to any other case or legal proceedings involving the alleged co-conspirator. What that's telling you is this: judge's instruction. You heard testimony about Charles Vallow. We've heard about that. We've heard a lot about it. Counsel brought it up again today. And I believe, if I remember right, I don't see him. Officer Duncan's here today. And Officer Duncan got on the stand, and when I pressed him, and remember, folks, I brought the paper out, brought the sheet of paper out, and I said, Officer Duncan, read this to the jury. Read what this prosecuting attorney in Arizona stated about the status of the case. And what did he say? Chad Daybell, with this in regards to Charles Vallow, no reasonable likelihood of conviction. What that means, they don't have any evidence. They don't have any reason. So, you don't get to say, well, he's guilty because he must have been involved. Charles Vallow, except the prosecutor said no reasonable likelihood of conviction. Lori Vallow's involved with Charles Vallow. Alex Cox, if he was not deceased, involved with Charles Vallow. Then we go to Brandon Boudreaux. Chad Daybell, not implicated in regards to Brandon Boudreaux. You know what Chad did? Do you know why he's not implicated? He carried a tire from a storage unit from a Jeep. And the prosecutor down there recognized you don't have an agreement there because you carried a tire. You don't have an agreement because Chad Daybell has religious beliefs that we don't believe in. What they have is they have Alex Cox shooting at Brandon Boudreaux and Lori Vallow down there involved. And that's what you have down there. Do not speculate as to any other case or legal proceeding involving the alleged co-conspirator. It's in black and white. Facts, evidence. Again, that fancy French word, voir dire. I talked to you folks about that. I talked about facts and evidence. Fact: Chad Daybell was not involved with Charles Vallow. Fact: Chad Daybell is not implicated with Brandon Boudreaux. Fact: Chad Daybell espoused religious beliefs. And if you want to believe the prosecutor, well, maybe Chad Daybell did a south-southwest search. Where's the agreement? Where is the agreement? It's not there. You must remember, the defendant, Chad Guy Daybell, has the presumption of innocence, and you must consider his innocence based solely on the evidence provided in this case. It's the judge's instruction. It's not their instruction. It's not the four of them over there. It's the guy that matters here, who sets the instruction and tells us the rules we have to follow. And the rule is, you must remember the defendant, Chad Guy Daybell, has the presumption of innocence, and you must consider his innocence based solely on the evidence, the facts and evidence that you have been presented. That's what you have to consider. We don't speculate. We do not guess. We do not engage in conjecture. We don't do any of those things. Facts and evidence. Facts and evidence. Reasonable doubt. Under our law and system, this is jury instruction number 5. Again, this isn't me speculating or saying anything, maybe making guesses, maybe giving you facts that maybe aren't consistent with what you remember in your notes. You all took notes. You all have a memory. I know it's been a couple of months, but you all took notes and you all have a memory. And the judge's other instruction would be rely on your memory. Rely on your notes about what you remembered, not what the lawyers say. That includes me. If I say something that's different than what you remember in your notes, you rely on your notes. They said something different than what you remember. You rely on your notes. You rely on your memory. That's the way this works. That's why we all have memories. That's why we all take notes. That's why we all document what has been said for the last 2 months. I watched all of you take very careful notes. I watched all of you document what was being said. Rely on your notes. Rely on your memories. Under our law and system of justice, the defendant is presumed to be innocent. The presumption of innocent means 2 things. The state has the burden proving the defendant guilty. The state has the burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Chad doesn't have to do anything. He could sit back there and just let the state do their thing. And if he did that and they never proved that there was an agreement, you can't say they put on more evidence than the defense did. That's not the way this works. They have the burden to prove that there was an agreement. They have a burden of proving that Chad in some way was involved in the murder. Now, the insurance cases go back to, well, if Chad was planning a murder, that way he lied and he took advantage of the insurance. And that's how that works. Because if you folks find that he wasn't involved in the conspiracy or the murder of anybody, there's no insurance fraud case. Doesn't have to provide any evidence at all. Now, 4 experts. Dr. Bartling, and we're going to get to that in a little bit. Dr. Hampinkian, Dr. Raven, Patrick Eller. He didn't have to do that. Chad didn't, it's not his job to prove innocence. It's their job and it's their burden to prove guilt. They have the obligation to prove guilt. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not mere possible or imaginary doubt. It is based on reason and common sense. So when you think about reasonable doubt, what you're doing is you're saying, okay, do I have a reason to believe or doubt whether Mr. Daybell is guilty, whether Chad did this? Do I have and using my common sense and reason Is it possible Chad's not guilty of this? That's reasonable doubt. If you're saying to yourself, I don't know what happened, I don't know the truth, I have no idea really, maybe we will never know what happened here. If that's going through your head, folks, and you don't know which way this is supposed to go, or you have some doubt in your mind whether the state proved their case, the verdict is not guilty. And under our system of justice, it has to be not guilty. Because you can't just bring a bunch of people in from a school who suddenly espoused that Tammy was perfectly fine, and one after another, and bringing the principal in, and bringing anybody who ever even spoke to Tammy once or once a week, or anybody else, and saying, oh, she was healthy. And yet they didn't show there was a significant discussion about her health. And we're not supposed to believe her family. We're not supposed to believe her son and her daughter who knew her better than anybody else. And then I guess what the state would like to do is, well, believe all of these 9, 10, 12, 15 teachers and principals and everybody else who was dragged in and said, oh yeah, healthy as a horse. Okay. Common sense. Common sense. That's what you need to do. It may arise from careful and impartial consideration of all the evidence or from the lack of evidence. If after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. If you have a doubt and you don't know what happened, you must find Chad not guilty. That's not from me. It's not from them. It's from the one that matters, the one who sets the rules and tells you what the instruction is, and read it for yourself. You're going to get a copy of the instruction. It's jury instruction number 5. You must, if you have doubt, Chad doesn't have to prove anything, but if you have doubt about what happened here, the verdict has to be not guilty. That's what the law says. This is jury instruction number 8. And I want to, when you pull up jury instruction number 8 with you folks in the booklets that you get, you'll see that I only took a couple of sentences out of that. In all fairness, jury instruction number 8 is much longer than this. And there's a lot more information in there. But what I did is I pulled out what the theme and what I wanted to talk to you about. And on jury instruction number 8, as part of it, it says, in determining the facts, you may consider only the evidence admitted in this trial. You consider the evidence that has been presented to you. There has not been any evidence saying, we're going to kill the kids. We're going to kill Tammy. There is talk about a plan. Yeah, the 144,000 building a village for the children, the infirm, the sick, the other people that Chad is able to gather. There's the plan. And if you go through the evidence, you'll see there's reference to the plan. It wasn't a plan to kill, folks. It was a plan to gather. A plan to gather by a gentleman who's a traditional Mormon. And yes, you don't have to like his beliefs. You don't have to agree with his beliefs. But he sure has the right to believe whatever he wants to believe. Second line, and again, you'll see the ... is because the jury instruction number 8, I want to say it again so that we're very clear. I didn't publish the entire jury instruction number 8. I took these 2 paragraphs out. And when you read the rest of it, you'll see it basically covers the same subject. There's other topics in there that talk about it. But under the second sentence, do not attempt to guess what my answer might have been or what the exhibit might have shown. That goes back to what I talked to in the very beginning of the trial. You can't speculate. You can't guess. You can't engage in conjecture. You can't say, this is what he must have meant, or this is what she must have meant, or this is what they meant by this. No, you look at the evidence, and unless it tells you something, you take the evidence as you take the evidence. Again, the judge's instructions.
Thank you. Please be seated. All right, I apologize. It'll take me a moment here to get logged on and then we'll get started. Okay, we're on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. The court's been advised that the jury has reached a verdict. The court will note the parties are present. The state's present with Mr. Wood, Ms. Blake, Mr. Wixom, and Ms. Beatty. Mr. Pryor's here representing the defendant, Mr. Daybell. And the court at this time is going to instruct the jurors to please be brought into the courtroom. That will include our alternate jurors as well to be seated. And then I will have the marshal get the verdict form from the jury once they return to the courtroom. So if they can come in at this time, we'll have them brought in.
All right, please. Here's all present accounted for, Your Honor.
Thank you. Please be seated. All right, the court's going to next just make a reference that there is a courtroom conduct order in effect in this proceeding to remain in effect. So I appreciate everyone complying with that order, as most of you have done throughout the proceedings in this case. At this time, then, the first matter I'd like to take up is to do a roll call of the jury for the record. So Madam Clerk, if you could please conduct a roll call of our jury to make sure they're all present and properly seated at this time.
Juror number 1, red card number 27. Juror number 2, red card number 219. Juror number 4, red card number 631. Juror number 5, red card number 653. Juror number 7, red card number 752. Juror number 8, red card 1680. Juror number 9, red card number 823.
Here.
Juror number 10, red card 1358.
Present.
Juror number 11, red card 1365. Juror number 12, red card 716. Juror number 14, red card 997.
Present.
And juror number 15, red card 1078.
All right. Thank you, Madam Clerk, for conducting the roll call. All right, at this time, I'm next going to inquire from the jury foreperson. Has the jury reached a verdict? All right, thank you. Mr. Bailiff, if you would please retrieve the verdict from the jury foreperson. Thank you. All right, the court has reviewed the verdict form. I'll note that all counts have been properly marked, as well as the verdict form's been properly dated and signed by the foreperson. The next step then is Mr. Daybell, if you and counsel would please rise, I'm going to have the clerk read the verdict.
In the District Court of the Seventh Judicial District of the State of Idaho and for the County of Fremont. State of Idaho plaintiff versus Chad Guy Daybell defendant, case number CR 22211623. Verdict. We, the jury, duly impaneled and sworn to try the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Question number 1. In regards to count 1 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception? Guilty. Question number 2. In regards to count 2 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Tylee Ryan? Guilty. Question number 3. In regards to count 3 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Joshua Jackson Vallow and grand theft by deception? Guilty. Question number 4. In regards to count 4 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Joshua Jackson Vallow? Guilty. Question number 5. In regards to count 5 of the amended indictment, is Chad Guy Daybell not guilty or guilty of conspiracy to commit first-degree murder of Tamara Tammy Daybell? Guilty. Question number 6. In regards to count 6 of the amended indictment, is Chad Guy Daybell not guilty or guilty of first-degree murder of Tamara Tammy Daybell? Guilty. Question number 7. In regards to count 7 of the amended indictment, is Chad Guy Daybell not guilty or guilty of insurance fraud? Guilty. Question number 8. In regards to count 8 of the amended indictment, in regards to count 9 of the amended indictment, is Chad Guy Daybell not guilty or guilty of insurance fraud? Guilty. Dated this 30th day of May, 2024, and signed by the presiding juror.
All right, Madam Clerk, thank you for reading the verdict. At this time, I'm just going to collectively ask the jurors, all of you, is this in fact your unanimous verdict on each of those counts? Very well. At this time, I'm going to inquire if the parties wish to have the jury polled. Does the state wish to have the jury polled?
No, Your Honor. Thank you.
Does the defense, Mr. Pryor, wish to have the jury polled?
No, Your Honor. Thank you.
Very well, then. I'm going to direct the clerk to record the verdict. At this time, then, this does conclude the guilt phase of this trial. Because the defendant has been convicted on counts of first-degree murder and conspiracy to commit first-degree murder, the state has filed a notice of intent to seek the death penalty, and so a second phase of this trial, called the sentencing phase, will be taking place next. We're going to take a recess at this time for approximately an hour. We will come back on the record and begin with the start of that sentencing phase of the trial. I would like to remind everyone that this courtroom conduct order is still in application throughout these proceedings. Thank you all for complying with that. We are going to take that recess at this time. Mr. Daybell is to remain in custody at this time for the commencement of the sentencing phase. And with that, thank you all, and we will be in recess.
All right, please.
All right, I'll see you guys back in Coburger. I'm just going to keep this streaming because we're getting the sentencing phase today. Crazy. So you guys feel free to chat here or come over to the Coburger hearing. I'll see y'all in just a little bit. Thank you.
All right, thank you. Please be seated. All right, once the jurors are ready to be brought in, they can enter the courtroom, please.
Yes, Your Honor. All right, please. Here's our President counter for you, Your Honor.
Thank you. Please be seated. All right, good afternoon, everyone. We are back on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. The court notes that earlier this afternoon, the jury returned a verdict of guilty on several counts that are subject to this capital sentencing phase, including in the verdict form counts 1, count 2, count 3, count 4, count 5, and count 6 of the amended indictment. The court at this time then is going to commence with the capital sentencing phase. I'll note that in this case, the jurors have returned, including the juror alternates that are here as well, and the 12 jurors who returned the verdict under Idaho Code 192515 subsection 5B, the court is using the same jury to conduct this phase of sentencing also. And that statute reads that if the defendant's guilt was determined by a jury verdict, the same jury shall hear the special sentencing proceeding. So we are in that special sentencing proceeding. As I mentioned, the jurors are here and present. And ladies and gentlemen of the jury, thank you for continuing your jury service. You've again been seated for your continued service in this case. And that's the matter we're taking up at this time. To give you an idea of just the schedule, the court has some preliminary instructions that are going to be read to you this afternoon. We're going to commence then with further evidence on the sentencing phase starting tomorrow morning after I read these preliminary instructions. And the court's proposal on our typical scheduled plan would be to start at 8:30. Is the state going to be ready to proceed at 8:30 with any impact statements that may be offered?
Yes, Your Honor.
All right, that's how we'll run the scheduling at this point then, and I'll inquire as to the jurors going forward. Also, the scheduling we'll have during this phase of the proceedings. They don't need to be limited to the timeframes we've had throughout the trial, including, depending on how long this takes, weekends. So I am essentially leaving up to the jurors their proposed schedule within reason of when we'll work through this proceeding. So the court is going to read some preliminary instructions then to the jurors. And again, you'll receive additional jurors when you retire to deliberate on this part of the case. But for now, the court will just read these and those will be included with you later. So in this case, the defendant in this case has been convicted now of the crimes of
We
first degree
literally
murder
waited
and
an
conspiracy
hour to
commit
find out they're
first
coming
degree
back in the
murder.
morning.
We will now have a sentencing phase of the
So
trial
they have to do all the
regarding
victim
those
impact
offenses.
statements.
Additional evidence may be presented during the sentencing phase. You should also consider the evidence presented during the trial. Before the death penalty can be considered, the state must prove at least one statutory aggravating circumstance beyond a reasonable doubt. If you unanimously decide that the state has so proven one or more statutory aggravating circumstances, then you must decide whether the imposition of the death penalty would be unjust by weighing all mitigating circumstances against each proven statutory aggravating circumstance. At a separate proceeding, the court will sentence the defendant for other offenses of which you have found the defendant guilty. Instruction number 2. Your duties are to determine the facts, to apply the law set forth in my instruction to those facts, and in this way to decide the case. In so doing, you must follow my instructions regardless of your own opinion of what the law is or should be, or what either side may state the law to be. You must consider them as a whole, not picking out one and disregarding others. The order in which the instructions are given has no significance as to their relative importance. The law requires that your decision be made solely upon the evidence before you. Faithful performance by you of these duties is vital to the administration of justice. In determining the facts, you may consider only the evidence admitted during this trial and during the sentencing phase. The production of evidence in court is governed by rules of law. At times during the sentencing phase, an objection may be made to questions asked a witness or to a witness's answer or to an exhibit. This simply means I'm being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and not to be considered by you nor affect your deliberations. If I sustain an objection to a question or to an exhibit, the witness may not answer the question or the exhibit may not be considered. Do not attempt to guess what the answer might have been or what the exhibit might have shown. Similarly, if I tell you not to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations. During the sentencing phase, I may have to talk with the parties about the rules of law, which should apply in the case. Sometimes that will occur at the bench. Other times you may be excused from the courtroom so that we can discuss those matters. You are not to speculate about any such discussions. They are necessary from time to time and help the sentencing phase run more smoothly. Some of you have probably heard the terms circumstantial evidence, direct evidence, and hearsay evidence. Do not be concerned with those terms. You are to consider all the evidence admitted during the trial and during the sentencing phase. However, the law does not require you to believe all the evidence. As the sole judges of the facts, you must determine what evidence you believe and what weight you attach to it. If any evidence is admitted for a limited purpose, you are not to consider it for any other purpose. There is no magical formula by which one may evaluate testimony. You bring with you to this courtroom all the experience and background of your lives. In your everyday affairs, you determine for yourselves whom you believe, and how much weight you attach to what you are told. The same considerations that you use in your everyday dealings in making these decisions are the considerations which you should apply in your deliberations. In deciding what you believe, do not make your decision simply because more witnesses may have testified one way than the other. Your role is to think about the testimony of each witness you hear and decide how much you believe of what the witness had to say. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to give such opinion, you should consider the qualifications and credibility of the witnesses and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled. Instruction number 3. It is presumed that no statutory aggravating circumstance exists in this case. This presumption remains throughout the sentencing phase and during your deliberations. The state has the burden of proving the existence of a statutory aggravating circumstance, and that burden remains on the state throughout the sentencing phase. The defendant is not required to prove the absence of any aggravating circumstance, nor is the defendant required to produce any evidence at all. The state must prove the existence of a statutory aggravating circumstance beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. That in this time then concludes the initial preliminary instructions for the sentencing phase. And the court is going to be in recess then until 8:30 in the morning, when we'll commence with evidence on that phase of the trial. Before we break for the day, does the state have anything further?
No, Your Honor. Thank you.
Anything further from the defense?
Nothing, Your Honor. Thank you.
All right, thank you. I'll note that the jurors will remain sequestered during these proceedings, and we'll begin again tomorrow at 8:30. Thank you again for your continued service, and that will conclude our matter for today. Thank you.
All right.
Prosecutor's closing argument. Today, we're going to take a look at the defense's closing argument, see what the best points are that they made, and then also break down the state's rebuttal. It's been a little while since we've done a live on Chat Daybell. A lot of pre-recorded videos that we've posted, premieres, been in the chats, things like that. But today, you'll actually be able to ask questions live, and we can talk about the ending of this case. There's going to be some polls about where the chat is as far as guilty or not guilty verdicts, or maybe a split decision. So let's get ready for that. Hit the like button, make sure you're subscribed, and we will start. So we start out here with John Pryor responding to what the state said, and then we get to the state's rebuttal. And I think it's really important just strategically as a lawyer, how you prepare for rebuttal. You already know what the defense is going to argue, right? We've been saying, I know what the defense is going to argue. I guarantee the prosecutors do. They've been working this case. They've been doing the discovery. They've been sitting there in trial. So you know a little bit about what they're going to argue, even if not exactly the way that they're going to argue it. So you have to have something prepared, right? You have to have something prepared because you know what some of the defense's arguments are going to be. But whatever arguments hit best in the defense's closing, you want to make sure you respond to them in your rebuttal. So it's a combination of something pre-prepared